Hello, I'm Alexander Jeffrey, a law clerk with the Clark-Esposito Law Firm PC, and welcome back to another discussion about export regulations. Every exporter is afraid of penalties, but it is almost expected that as their businesses grow, that they will be penalized by either BIS, the Bureau of Industries and Securities, or OFAC, the Office of Foreign Asset Control. However, as the businesses expand, they become less cautious and are more likely to be less compliant in their actions. But how bad can these penalties be? Both BIS and OFAC have statutory guidelines for their penalty assessment processes. Both of these agencies have a sliding scale that ranges from mere warnings to criminal prosecution. Any export violations are held to a strict liability standard, meaning that regardless of whether the exporter knew of the violation, they are still held accountable. There are a variety of factors that both OFAC and BIS look into when they're determining the severity of these penalties. For BIS, the severity of the penalties is highly contingent upon whether the violation was considered a criminal action. Non-criminal actions are subject to civil penalties. Civil penalties may be up to $12,000 per non-compliant transaction. Additionally, if a violating shipment is subject to national security controls, the fines may be up to $120,000. On the other hand, criminal penalties are much more severe. For companies, they may be fined up to $1 million or 5 times the amount of each violating transaction. For individuals, they may be fined $250,000 and face 10 years in prison. OFAC also has a wide range of penalties that they issue to exporters that interact with blocked or sanctioned individuals or entities. The severity of these penalties is actually dependent upon which federal regulations are broken in the export transaction. OFAC makes a strong point for exporters to know that if they discover a past violation, that they must voluntarily disclose this to OFAC. Voluntary disclosures allows OFAC to mitigate the penalties to half of the statutory amount. The statutory maximum actually ranges from $65,000 to $250,000, and in some cases may even be twice the amount of the shipment in question. Other factors allows for OFAC to either mitigate or agitate the amount of penalties, including the status of the business's compliance program or how egregious the case was. Are you more curious about the mitigating factors? Are you facing a penalty from either one of these agencies and don't really understand why? Or think you may have a problem in the future? Contact us at the number listed or send us an email at contact@clarkespositolaw.com. We would love to hear about your business.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.